And what causes them? The devil's in the details. If you ignore the devil, it's likely to come back and haunt you. So failure to follow the bylaws is a common cause of claims against you as a board member. Out of sight, out of mind, meaning failure to update or memorialize amendments. Penny wise and pound foolish. Failure to hire critical professionals. Ignorance is bliss. Failure to know and follow new laws. And I'm reading from, by the way, it's off a website. It's ihginsurance.com, IHG Insurance. This is probably one of the best directors and officers forums for understanding the insurance for you folks. And they just spell it out clearly as I'm reading what causes it, why is it caused, how can you avoid it. So I could go on and on, but wanted to just give you some ideas of what causes these claims. Thankfully, most of you, I would say most of our insureds that we work with are not getting into trouble. So that would indicate that they're listening to their attorneys, they're listening to their counsel. Catherine's doing a great job of leading you and guiding you, and that's very important. So I hope I've answered that question. What liability does a board member have? I would just say a lot. I've seen over the last 10 years, there are more liability going on a board member than ever before. I mean, you have a requirement to understand Florida statute. That was something that was not part of the program, I don't think 5 or 10 years ago. So when there's a requirement to do something and we don't do it, then that puts us in a position of being at risk of breaking the law. So it's a big deal to be a board member, and that hiring the critical professionals, whether they be management companies, attorneys, insurance firms, whatever, those three in particular, is critical to doing things right and protecting the membership and staying out of trouble. I'm going to move right now. This is the last question I have. What responsibility does the association have in regards to insurance coverage issues versus individual unit owners? So if we had a hurricane and the wind blew, broke a window, raised a roof, rain came in, water came in, did damage to the exterior and the interior, the unit owner is responsible for the inside of their unit, the paint, the floor coverings, their attachments, their cabinets, everything within the unit. The problem becomes, and this is what this question is getting to, is what happens from rain damage caused by a roof leak? Well, this is a problem because I could almost be certain in this case that this will be an uninsurable event. So if you called me and said, Mike, we had torrential rains this past weekend, a few owners are having water coming in, and we've got some expenses here. I know in my heart, knowing what I know about what triggers insurance and a claim and a covered claim, that's like 99% not going to be covered. So what I've seen, what I think you need to do is look at your documents and find out who is responsible for what in that case. When it's an insurable event, it's easy. When it's not insurable, like this roof leak, which is like maintenance related, then look to your docs. And I would say if it's not in your docs, I would definitely recommend that get clarified, because as buildings get older and if they're not maintained properly, we're going to have more of these issues coming up, and they need to be addressed and put into writing into your docs beforehand. That's everything I've got. I appreciate your time.
This way. Thank you, Mike.
You're welcome.
Sorry. Okay, everyone. Diane, for those that just popped in and are just getting in now, Diane Michael with Southern States Management Group. I just got a message from someone that's on the call, and the speaker view is actually the best way to view, so that you can just see the person that's speaking, because our next two presenters have PowerPoints. That way you don't have to see everyone. So if you just go to the top and where you have your view options and select speaker view, that would be great. Additionally, I would like to very briefly say our disclaimer again, because I actually wasn't recording. So thank you for letting me do this. By being involved in this platform, you are authorizing permission for this to be a videotaped and you're giving us permission to allow us to videotape and upload to our website. Additionally, no reproduction of use of this video may be made without prior written consent. So thank you. And then again, for those that are wanting to ask questions, we'll have a Q&A at the end. And if you look at the bottom of your screen, it says chat, and you're gonna wanna make sure that you're sending just Diane Michael your questions. There's an option for everyone, or there's an option for just me. And if you could start off with your question by saying legal, insurance, or management, I'm going to be filtering that so that we can get right into Q&A after. So without further ado, Catherine Miller, if you will unmute. We have Catherine Miller here with Wright Casey, and thank you so much. Yeah, I'll unmute you.
Okay, can everyone hear me now? Great. Let me share my screen and get my slides up. Can you see my screen? It should say coronavirus, common areas, and cancellation of meetings, right? The big question is, what is my association allowed to do right now? I am Catherine Hurst Miller from the law firm of Wright and Casey, and have some big picture ideas that are going to be important and that deal with common areas and meetings for years to come, but really wanted to focus on the critical question of the moment, which is, you know, what can I do with coronavirus going on? And as a follow-up to Mike Mort's presentation and talking about insurance, the question is, you know, am I insured for coronavirus? It's totally unclear. I have a friend whose law firm got hired just to answer that question in hundreds of cases, or hundreds of policies. Her firm's out of Tampa, and so, you know, her whole law firm is going to be taken up wondering if they're insured for coronavirus-related claims. Let's take a step back and try and not have coronavirus-related claims, right, at your association. So let's talk about what we can do and not do, and what's going on right now with our boards, our common areas, our meetings with coronavirus. We are in a state of emergency in Florida. I heard, and we'll talk about, you know, trusting correct sources, so I'm not sure that this is a correct source, but this is the first time in American history that all 50 states have declared states of emergency. So Florida has declared a state of emergency, and it's an evolving situation, as you know. Some of you may know the governor is speaking right now. I'm kind of trying to follow that on Twitter as we go along, and he's unveiling this plan called Safe, Smart, Step by Step, a plan for Florida's recovery. You are required to follow the governor's executive emergency orders, and I'll tell you where you can find those. You're also required to follow any DBPR, that's the Department of Business and Professional Regulation emergency orders that apply to condominiums or HOAs. We've really only seen one major one, but the DBPR has also issued some of the emergency orders that are applying to our businesses, and so we get more detail on, you know, what restaurants can and cannot do, or what gyms can and cannot do, or what other regulated industries can and cannot do. The Florida Department of Health has a lot of valuable information, and we're required to follow some of their requirements and reporting. We've seen questions about reporting going along. And we're also required to follow any local municipality orders. So if you live in Palm Coast, you're following both Flagler County orders and Palm Coast City orders. If you live in New Smyrna Beach, you're following both Volusia County and the New Smyrna Beach municipality orders, and they may be different. And on top of that, you know, our courts are doing very limited things right now. They're trying to gear back up. But if you get a specific court order that relates to your association or to people in your association, obviously you have to follow that. Courts are enforcing quarantine orders. If someone has been diagnosed with coronavirus and is ordered to stay home and is refusing to stay home, the courts are taking up enforcement of that. You're advised to follow the CDC guidelines, any reputable news information sources. Your lawyer and your management company, hopefully, folks on this call are using Southern States or looking into using Southern States. Really a valuable source of information there. I would avoid following non-informed opinions, right? So like if my father-in-law has sent you an email saying if you hold your breath and can still breathe, you don't have coronavirus, that is not an informed opinion. I don't want you following the forward emails. I also don't want you doing something just because the condo building next door is doing it. I've had a lot of questions like that. Well, next door they're doing XYZ. Do we have to, do they know something we don't? Possibly not. Talking about the executive orders from the governor, they're all online. They're really easy to find. And they're there at floridagov.com/2020 executive orders. If you just do a Google, you can find the executive orders, Governor Florida executive orders. You can find them. There are a ton of them, and you can scroll down and see them all from yesterday's date back through the coronavirus emergency. I'm just scrolling here on my computer. Back here is when we see the 323, 324, a lot of the orders that relate to this month. But we're a declared public health emergency back on March 1st, 2020. So you can go back to those executive orders, and things are changing right now. Again, the governor's holding a press conference. If you're interested in the DBPR, the Department of Business and Professional Regulation emergency orders, you can find those on the DBPR website. They're on the front page of their website. They have an emergency link. There is one specifically about condos and HOAs, and all it does really is clarify that, in fact, condo and HOAs emergency powers are able to be used. That's why I'm talking so much about these emergency orders. Well, in a declared state of emergency, we have emergency powers that are available to condos and HOAs. And I've talked about these before. Some of you have my postcards on these. We all thought this was something that happens after a hurricane, right? We can conduct board meetings after providing notice in a manner as practicable as possible. We can cancel and reschedule association meetings. We can designate assistant officers from folks who aren't on the board. We can relocate our office if we need to, right? Those all make sense during a hurricane. Well, they're also all available now during this coronavirus emergency. Same thing with debris removal. Probably not going to have that. Probably not going to be implemented a disaster plan, but if you had to, you could. You may have to determine if a portion of the association property is unavailable. We'll talk a little bit about that as it relates to gyms or pools or other common rooms. It is possible you could be mitigating further damage as you were doing some sort of cleanup of coronavirus. You can also levy assessments without owner approval and borrow money and pledge association assets as collateral to fund emergency repairs. And we'll talk about a little bit about that because I have had questions on those specific topics. Condominium associations also, when we're talking about emergency powers, they have 3 extra ones that can require the evacuation of the condominium, but only in the event of a mandatory local evacuation. They can determine whether the condominium property can be safely inhabited or occupied with emergency management or other safety professionals, and they can contract for unit cleanup. And again, the only time I really could see that coming into play is where there's a unit that needs to be professionally cleaned because someone with coronavirus has been in there. On common areas, so the emergency powers that most affects common areas is that a condo or HOA board can determine if a portion of the association property is unavailable for entry or occupancy. But generally, the board has a lot of power over common areas. The board oversees common areas. The board can enact rules. Now, the rules have to pass a reasonableness test. So the rule can't conflict with the declaration. If the declaration says, X, a rule can't say not X. But as long as it's not contravening something that's implied in the declaration, and as long as it's reasonable. Some of you have heard my example. You could have a declaration that says everyone has to wear yellow shirts on Tuesday, and if that's in your recorded declaration and has been there since the beginning of time, everyone in your association has to wear a yellow shirt on Tuesday. But you can't make that rule, right? That's not a reasonable rule. It doesn't relate to the health, safety, happiness of unit owners. I am thinking that things that the board comes up with in its best judgment about coronavirus are going to have a clear relationship to health, safety, happiness of unit owners. You can do more than is required by emergency orders. You cannot do less than is required by emergency orders. So if your board says, we're not so keen on the social distancing and we want to leave all the furniture at the pool in a tight group together, 20 chairs, row after row after row with no spacing in between, I'm not comfortable doing that, right? I want to see that you have only 10 chairs out there, right? Because we're allowed to congregate in groups of 10 or fewer. Or I want you spacing the chairs out 6 feet apart or more. And let me go to my next slide. Let me talk about pools specifically. I got some questions about that. Should our pool be open? Should our pool be closed? The answer is maybe. I don't have a clear answer. I do know that there was some discussion that Volusia County issued an order that said community pools are closed. And then shortly after that, the governor issued the Safer at Home order, and it specified swimming. And Daytona Beach, after much follow-up, gave me an interpretation that did not apply to condo and HOA pools in Daytona Beach. So there's no emergency order that shuts down pools that I'm aware of anywhere in Volusia or Flagler County. But the board can do more than the emergency orders, right? If you think it's not safe to have your pool operational for any reason, then close your pool. If you think your pool needs some modifications, no more than 10 in the pool, or let's spread out the seating, or let's take away some seating, if that feels appropriate for your association, then please do that. Should our fitness room be closed? Well, our Safer at Home order expires 5/1, so that's Friday. So definitely your fitness room should be closed right now. To talk about reopening it, again, you can do more than the state requires, but we're also going to be looking at kind of what opens up and in what order. Are gyms allowed to be back open next week? If gyms are allowed to be back open, you may want to open your fitness center, or maybe you don't. You just figure out what's right for your association. Should we be doing more cleaning and enforcing social distancing on common property? Yes, right? The board is in charge of the common property, and they're delegating that through your manager, through your on-site staff, or however you're organized. But I'm expecting my clients to be doing more wiping down of doors, more wiping down of elevator buttons. And you don't want to create some expectation that you're doing a lot and you're able to protect people from all unknown, because you're just not. But you want to do what you can, what is easily able to be done within your organization, within your budgetary constraints. You want to create a safe environment for your residents. A couple more questions on common areas. If you're going to change, your policies about common areas, or really about anything, should owners be notified and allowed to comment? Well, maybe. If you're making a change in an HOA about a lot, a house, or in a condo association about a unit, statutes require 14 days notice for rules about policies about something that's going to happen inside a unit or on a lot. But if you're talking about the common areas, maybe not, right? We're not going to need to have a meeting to pull some furniture away from the pool. We don't need to. If you think it's right for your association and you want owner input, you want to have a meeting, have at it. But if you don't have to, is what I'm saying. If you're going to do a complete rewrite of the rules, or add a brand new rule, or do something with some lasting effect, I would recommend, my advice is the best practice is to publish those ahead of time, or to put it on the agenda in a way that is going to allow owners to know this is coming up. And if I care about whatever our rules generally, or the pool rules, or the architectural covenant rules, or the color of the building rule, whatever it is, I want to get some idea from an agenda or from a notice that that's coming up, so that if I care, I will make arrangements to be there at the meeting. How do we update our rules? Well, the board is in charge of writing the rules. You can delegate to a committee. You can have a single person do it. The board can brainstorm together. The board can be sending emails back and forth, but not voting, right? Voting happens at a meeting. We'll talk about that when we talk about meetings on the next slide. But at the meeting, you're going to have noticed your rule if it's a brand new rule, and you're going to have a board vote, and then that's the rule after the board votes. Again, best practice would be to send that out to everybody, put it on the website, make sure people know, get it posted. But it's not that hard to change a rule, as opposed to changing a declaration or a bylaws. Those require typically a owner vote. The rules typically only require a board vote, unless there's something really unique in your declaration or your bylaws. If you're an HOA, this year or last year's statutes now require your rules to be recorded. I don't think that applies to like a posted pool rules, but if your whole HOA rule system, if you're developing new rules, not just pool closes at dusk or something, but you're developing new substantive rules, then you want to have those recorded if you're an HOA. That statute does not apply to condos. How do we enforce the rules? Well, you got to make sure people know the rules. So that means sending out reminders or making announcements. And there need to be consequences for violating. So it can be written warning from the board, from the management company. It can be starting your fine committee. We've had whole seminars about the fine committee. And if people aren't paying fines, then you can suspend their use and voting rights. Another thing you can do during emergency powers time is cancel meetings. And really, except for your annual meeting, which a lot of declarations require that the annual meeting happen on some specific day and time or some generally described day and time, the board has a lot of flexibility for the board meetings and when those get scheduled and rescheduled, as long as there's not some requirement in your declaration or your bylaws. So your declaration or bylaws may say your annual meeting is May 5th. Cinco de Mayo is our annual meeting. Well, that's coming up, and I'm not sure that we can get everyone in a room safely. And so we need to think about canceling it or rescheduling it or holding it in a different way this year during coronavirus or whatever emergency is going on, right? It's the emergency powers that allow us to make changes to our annual meeting. I have had a lot of associations that just canceled their meetings, and I'm telling them, try to use a Zoom or a GoToMeeting or a Facebook Live or just a conference call, a freeconferencecalls.com to hold meetings. Right, you can hold them in a different format. I think that is completely allowable under the emergency powers. And again, you do want to provide some sort of notice that the meeting is going forward in a different format and how people log on. But you can't, totally cancel the meeting and never reschedule it. And you can't totally ignore the emergency order and say, okay, I'm going to have a in-person meeting of 200 people. We're not going to do that. Question I get, can the board just vote on it by email instead of a meeting? The answer is no, right? If the board votes, I say this over and over again, Fred Annan of Southern States, Troy Railsback of Southern States, Jeff Annan of Southern States, they say it over and over again, can you have a email vote instead of a meeting? No, a vote needs to happen at a meeting. Do we have to follow sunshine law? Well, sunshine law is really only applicable to states or municipal governments. But your association business needs to happen in the sunshine of its owners. So the owners need to get notice of a meeting cancellation, notice of a meeting rescheduling, notice of a meeting happening in some different format. And if you have owners that need accommodations, maybe someone is deaf or hard of hearing, we need to figure out if we need to accommodate them with a sign interpreter, or how we hold a meeting virtually if someone has blindness and we're doing a Zoom meeting, making sure that they can be accommodated and they have access to the meeting. I also got a couple of questions just about special assessments, and special assessments, there are some emergency powers that relate to them. So you can levy assessments without owner approval as an emergency power in a declared state of emergency under Florida statutes. Most of my association documents allow the board to levy special assessments anyway without owner approval. You do have to have 14-day notice, and I don't see anywhere that that is no longer required. Again, if you had to drum up some money tomorrow for something related to the state of emergency, maybe, but I'm not seeing that right now. I'm seeing a lot of people say, oh, great, I have this ability to do some sort of special assessment or borrow money from a bank relating to, that doesn't relate to the emergency, but during this emergency disaster declaration, emergency declaration. And I am very cautious about that. That's something that I think could get a board in hot water if you are using your emergency powers kind of for non-emergencies, right? If you say, oh man, now would be a great time to do a new roofing project and we don't have that in our reserve, so let's do a special assessment and let's do it without owner approval and without notice, and let's borrow money from a bank. We don't have to tell the unit owners that. It has nothing to do with coronavirus, right? We're in a coronavirus emergency. So I'm less excited about a special assessment without owner approval, without notice, without relating it to the coronavirus emergency. I will obviously answer more questions. Diane is going to collate them and ask us at the end. But if you need to contact me, here is my information. Again, I'm at Wright Casey. We've got our phone number there. You can email me. I know there were some specific questions about foreclosures and city sales or county auctions, some things about special assessments that may be very specific to a condo or an HOA. And I would prefer to answer those, in a one-on-one conversation talking about your documents. Right now, I'm trying to talk about general powers, but everything's always kind of controlled by your individual documents. So, except for the emergency powers, which specifically override, what's ever in the documents. Okay, I'm going to stop my share and turn it back over to Diane because I know Troy Railsback has a lot of great information to share.
Thank you so much, Catherine. As always, you're absolutely amazing with all your information, and we thank you so much for being part of this. Okay, we have Troy Railsback. I'm going to unmute Troy. He is with Southern States Management Group, and he has received a number of questions from you, and I'm compiling your questions again. If you have questions that arise already, we've gotten a number, and thank you everyone for following directions. But if you do have more questions, you simply go to the bottom of your screen, and where it says chat, just go and select that. And then instead of selecting to send your question to everyone, please send it just to Diane Michael. And if you could please just put either legal, insurance, or management first so I can compile it quickly. And then Troy, without further ado, I'm going to stop my video and mute. Troy, are you there?
I am. Can you guys hear me?
Yes.
All right. Hopefully everyone can see the presentation. Good evening, everyone. Thank you for joining us in this format. We appreciate the opportunity for us to present to you. And I'm just going to take a few minutes to go through some of the slides that we prepared. And then along the way, I'm going to try to answer some of the questions that we received in advance and that Diane has already received. So one of the main things that I first that came to my mind as we entered into this situation is, a lot of people are going to say, all right, so what happens? Does everything stop? Does, everything to landscape maintenance, to paying your assessment, to, what can and can't the association do? And they have board meetings or they don't have board meetings. So the information that Mike presented regarding your insurance, that's a lot of stuff that you have in play in advance. And as the board operates and does things under emergency powers that Catherine covered. Your D&O policy for the insurance would protect you as long as you're operating in the confines of the orders, as Catherine explained. So now down to the nitty gritty association business. Internally, we had a little bit of a chuckle to, when they came out with essential business services, the community management, community association management, and real estate are essential businesses. And so the internal joke as well, so we really are recognized as an important function in everyday lives. And we all know that, those of us who've been through one of our presentations before, and specifically one that I've given, is, we take very seriously the association's operation. It is a business. It has shareholders, and you want to protect those shareholders' value. The shareholders are the members, and the value to the members is their asset, their home, and or the common areas that they share a common interest in. So one of the first questions, emails that started trickling through, questions that came in when we put this out is, what happens to collecting assessments? Do people have to pay? And so, the association, it never stops. It needs to have a fiduciary, acute collection policy, and it should have already been in play. So if it's not in play, if it's not something that you've worked on, now's the time to think through it. I think throughout this presentation, the main thread, the main message that I want to reiterate is the association needs, their best day is when they're equitable, non-selective, and consistent in whatever they do. So when it comes to collecting assessments, you should have by covenant or document, you should have a late fee opportunity and finance charge in a period that allows owners to pay. It's due on the 1st, late after the 15th, or whatever. And so you should have a reactive mechanism if someone doesn't pay after that 15th time frame or whatever it is. And what I want to be able to do is, just give you a few little tidbits of, what a best practice looks like. If you have a collection policy, hopefully you have it on a website or in an owner portal that people can see. Hopefully you've mailed it out when you mailed your annual assessment or your assessment coupons, or your adopted budget, and everyone knows what happens if they don't pay. And so there's nothing that I'm aware of, and I'm not an attorney, I can't render a legal opinion, but there's nothing that I'm aware of that would allow an owner just to stop paying because of the coronavirus pandemic. You still have that obligation to the association. And some of the things that come to mind if you're questioning why you need to continue to pay, if maybe, as Catherine mentioned, the pool's not open or you can't use that fitness area. Well, that fitness area and that pool, it still has electricity. The pool still needs to be cleaned and serviced regularly. Those things probably shouldn't stop. You can probably limit cleaning areas like the fitness area. If no one's accessing them, you can limit it and pull your scope back a little bit. But at the end of the day, you're going to ramp that scope up when you do reopen. So you'll have you may have a little cost savings initially over the first 2 or 3 months during this pandemic. Who knows how long it will last? But as you reopen, you're going to ramp up that level of service and scope of service, and you're going to end up paying more probably for the next 2 or 3 months, and it will even out. We talked a little bit about elevators and cleaning the buttons. The assessments that are out there, they pay on a monthly service and for emergency basis for that elevator to be able to operate, and for the landscape service personnel to come and perform their scope of service, and for the access control that you are finding is more critical than ever, for that function to operate at the highest level. That, that's why you have that asset that you pay in every month or quarter or annually to make sure that the responsibilities of the association are being endeavored and delivered at the highest level, especially when people are in their house at that time. You want to make sure that they feel comfortable with what the association is doing, and turning off the pool and letting it turn green because you aren't letting people in there. That's not an option. You still have to service that pool area. And one of those, again, consistency and people understanding that collection process and what their obligations are save a lot of time and effort trying to explain them now, when from my perspective, it's business as usual when it comes to what you're endeavoring to do. How we're doing it via a video conference or over the phone, and not necessarily face to face with a board or an association member, yes, that's different, but the association is still obligated to deliver those association responsibilities, and basically figure out how to navigate through this unique experience that we're all in. So let's talk a little bit about what happens if you aren't business as usual, sending your late notices, and endeavoring to collect assessments. Well, if you aren't doing that now and you were doing it before, you have an inconsistent policy in practice, and you have exposure as an association. And this, as that delinquency builds up, you have a financial hole that the entire association now has to address, in addition to all the other things that are happening around them. And so, if you historically have set your policy, or you have just what you normally do when people don't pay their assessments, keep doing it. And the only new thing that, our best practice, what we're implementing with some of our associations, is if you've identified, okay, if someone's behind in their assessment and you're giving them 12 months to catch up, and identify a payment plan and have them put it in writing, and your max time frame is 12 months, which we think is the best practice. Then if someone says, I'm out of work and I can't, make a payment, or I'm doing this, or I have to, kind of navigate for the next 2 or 3 months, then get in writing what they're planning on doing and obligate them to do it. Because down the road, when they don't do that, that's another piece of information that you can pass over to, Catherine's group or whoever your attorney is, to collect that assessment. And, you're offering it to everyone who needs it. I don't think an e-blast or an email needs to go out that says, hey, we're giving you a grace period. But if you, on an individual basis, when the associations that we manage, when we're looking at someone who has a delinquent assessment, we're asking them, pay your assessment. If you can't pay your assessment, we're going to do 45-day delinquency notice and potentially a lien foreclosure action down the road. And when they are confronted with your late notice or delinquency notice, if they call you and says, I can't pay because I'm out of work, then what you would do normally with someone who's maybe 6 months delinquent is you would arrange a payment plan with them. So give them that opportunity. You're now being consistent. You are someone who can't pay their assessment and they need a time frame to address it and write their financial position. Then that's, from our perspective, that's perfectly equitable and consistent with what you've been doing in the past, and it will allow those association members to continue to meet their obligations down the road. They just don't necessarily can't do it because they're out of work, maybe that 1 month or so. Again, not something that's an e-blast and you make it public so everyone stops paying for a month or two. It's just, that's how you're going to address those owners who really genuinely come to you and say, I want to pay. I've always paid. You can look at my history. I'm unable. I do not have the money today, but I'm willing to make this commitment to you in 3 or 4 months or whatever it is. So that's an individual case by case. There's no one size fits all for that, but I just wanted to kind of the grace period thing. I think, as if you are faced with that, I wouldn't be afraid to offer a payment plan and have that be very similar to what you've done for other association members in the past. Southern States Management Group has a real estate brokerage. I'm the broker for the real estate entity. I see a little bit of a different exposure for the association as well that I think everyone would recognize. If you've ever sold your home or attempted to sell your home, and there's maybe a property next door to you, or something that you feel that's detracting from your ability to sell, all of those things are super sensitive when you're trying to sell your home. So the association's financial position and not being proactive and consistent, equitable, non-selective in collecting assessments, and we'll talk a little bit about compliance, in not doing those normal business as usual, as I said before, the association may have some exposure. The association really needs, through its management company or however you're doing it, really needs to attempt to operate with social distancing, adhering to the municipal and governmental orders, but attempt to operate and do the things that that you're responsible to doing for the betterment of every member of the association, and obligating every member of the association to make sure they pay and keep their property in compliance consistently, equitably, and non-selectively throughout the entire community. A few of the questions that I got, I want to answer with the business as usual. How do you handle renters' non-compliance? And what do you do in neighbor-to-neighbor disputes? Maybe some of this stuff comes up. These are things that the association has faced in the past. I would be surprised and shocked if any participant on this call has not had an experience with a renter who may not be doing the right thing in the community. The owner is responsible for their tenant. Your notification process, whether it's a series of letters and it goes to a finding committee, or engaging your attorney after you send them an email or a letter that says your property is not in compliance and your tenant, and you may make a phone call to the rental management company and or the owner, you need to just do that. Yes, we want to be sensitive to property owners during this time, but because there's a pandemic doesn't mean that all of the covenants, conditions, restrictions, and obligations of every owner and or their tenant or guest goes out the window. All that stuff, again, business as usual. If you have a manager or someone who's able to, or is riding around and doing compliance, they can do that from their car by themselves, socially distanced from anyone and everyone that they need to be, and document covenant violations. I can tell you within our core business, we're moving ahead with compliance effort. We have an insert that goes in with our letters. We felt it was a best practice to use our same letter series and not change anything, and put an insert in there that basically states we're aware of the pandemic and circumstances for property owners to bring their property in compliance in the immediate 14-day request or whatever. Please let us know when you're going to be able to address this, and please understand that you do have to keep your property in compliance, something to that effect. And that goes in with our correspondence. And so we're telling them that business as usual. You have obligations as an owner, and if your tenant or a member of the association is not upholding what their commitment is through the covenants, then they need to be properly noticed, documented, and it needs to be ready and in the queue for the next step, whatever that is down the road. And that's the association circling back and being consistent, non-selective, and equitable in every facet of its deliverable. And when it comes to neighbor disputes, if it's not an association responsibility, if if it's something that really, there are things that when one neighbor either has a grudge against another one, or they were happy that their neighbor traveled a lot and he was never there, and now he's home all the time and they don't get along, you refer them to the police if there's a safety issue or whatever. There's certain things that the association shouldn't get its hands in, but we all can navigate those individual circumstances, and the association really should just, again, do the same things that you've been doing, whether it was November last year, February this year, or April this year. You should be doing the same stuff. So as far as Catherine's comments related to board meetings, I want to elaborate a little bit on that. What we've done, what we found is most effective is, yes, we canceled a meeting or two for some of our associations. Many of our associations missed the March meeting because it was so fresh and new, and if we didn't have it at the beginning of the month, everyone was supposed to stay home. So here we are. We had our late March meetings, early April meetings. They were all basically canceled. And so we're always encouraging the association to be as transparent as possible. There's no secrets. The association and its membership should be aware of what's going on all the time. Hence, Catherine's in our consistent messaging of board meeting votes via email is not appropriate. What we found most effective is, yes, you can do visual meetings in this format, but we made in one of our main associations, we made the board meeting a telephonic or teleconference meeting. So the board, is on the call, and any association member that wanted to call in, this community has almost 2,000 homes in it. Okay, so we sent an e-blast and put a notice out there that said the board is going to have its April board meeting. The meeting is going to be conducted via teleconference. If you'd like to participate exactly the way you would participate in the meeting by sitting in the audience, please contact, and it was me because I was the manager, please contact Troy Railsback. And we had about 18 property owners out of almost 2,000 owners wanting to call in. So we gave them the call-in information. We gave them formal instructions about muting their phone, when they can participate. We made taglines to say, when you hear either the board president or the person conducting meeting call for a vote, or have a motion and a second, board discussion. Is there any audience comments or input? At this time, we'll take that. Please unmute your phone, state your name and your property address. And that's how we did it. We're doing the same thing with ARC meetings. We're about to have our first compliance meeting in May. And our plan is to do it that way unless orders allow us to meet in person. So back to the main thread of what we want to tell everyone is, it's business as usual. You should be consistently, non-selectively, and equitably fulfilling your association responsibilities in every facet that you can, unless there is some specific reason that you can't. Some of the other questions that I got were related to security and access control. I touched on that a little bit. I want, just to reiterate, we're going to talk a little bit about VMS and some of the software and account and data organization and retention that we have. This is why we've invested in technology. This is why we do all those things. So people who should be in a community and should have access and should have a transponder or a gate key or whatever, we can turn those things on and off. And if association members stop paying assessments, and the association's policy is if you're 90 days delinquent or 60 days delinquent, your transponder stops working, business as usual. They should not have access to certain amenities and areas in the community. And you should, turn all those things off, the same intervals you turn them off. And then when the order is that you can now go back to your fitness center, if someone hasn't paid for 3 months, they shouldn't have access to the fitness center. So just, another little specific question and instance that would apply. one of the questions, how do you enforce rules or covenants without a fine committee? The best way to navigate through covenant issues is to establish, one or two main, either one or another main path. You're always going to send a notice to an owner. You're going to send something, typically with a photograph, that tells that owner that there's an alleged violation. That we see something on your property that we feel is not in compliance with the covenants. Okay. The next step, if they respond or not, is to advance that if they don't correct it. So let's just say, for something as easy example, they have weeds on their entire property, so they're not maintaining their property. So it's in their brick pavers, it's in their landscape beds, it's all throughout their lawn. So you send them a letter, your property's not being maintained, you need to, get rid of all the weeds on your property. And if they don't do that, the next step would be follow the Florida statute 72305 on levying a monetary penalty with the fine committee, or you would send it to the association's attorney and have them demand that it get corrected. So ultimately, the association has a path that it would go down. And so if you don't have a fine committee or you don't have people participating, you have to invest in a cost of doing business and send that initial letter from the attorney obligating an owner to get their property in compliance. And ultimately, down the road, if it becomes a lawsuit, the association should recoup some of those costs or all of them. That's a Catherine specific instance, but the association, when it goes into the lawsuit, and typically your documents provide it, if you win that lawsuit and it's clear that you're going to win it, then your investment in addressing that typically will get returned in awarding the lawsuit. Now, we all know, whether it's a foreclosure or something else, there are instances where stuff gets written off. But what I'm talking about specifically is if we're having trouble with an owner who just is digging their heels in, if you don't have a fining committee, our best practice, our recommendation to our clients is to engage an attorney, have them send that formal form letter. It's a letter that you've created through them that you've done in advance, and they populate the information. Hopefully you've talked to them about the costs on it, and you send that letter out. And you shouldn't stop doing that because there's a pandemic. Let's talk a little bit about VMS and how board members can continue to interface with the management company and or the association business. So our owner portal has a board level group that would allow board members to see financials, compliance reports, architectural reports, delinquency, account balances, those types of things in real time. So what that allows us to do is, number one, it makes us and obligates us as Southern States Management Group to do business as usual. Go to the PO boxes, collect all the mail, process all the financials, do all of those things so the association has a pulse on what's going on. So when the property at 123 Main Street says, "What are you doing about 125 Main Street?" They have weeds in their driveway, and I don't think anyone's living there. Are they paying their assessment? And whether I've called the management company or I can't get a hold of anyone, if a board member gets that question and they're our client or they have the ability, they're using VMS, they can log right in and see if we've sent them a letter, 125 Main Street, look it up, see what their account balance is, and provide cursory or treetops information to that adjacent property owner to say the association is on it. We're doing our consistent, equitable, non-selective enforcement and collection policy, and there's the next step is to do the advanced collection or advanced compliance, which would be a fine, or send it to the attorney. And once the timeframes expire in accordance with our policy, we are going to take that action. The direction to the management company is to advance those things as we would normally. again, back to the business as usual. And that will navigate the board through a lot of those questions and provide comfort to the association members that everything is continuing on, and the community is not, gonna, take a dive because everyone says I have to social distance and the association can't operate. And so, and as I said, we have board member level groups in VMS. It's very customizable. You can have an art committee or a compliance committee, and they're going to see architectural agendas and things that are logged in for them to review. And we're doing that remotely with our ARC meeting. So a quick tidbit on that. So our architectural 7-member committee would generally go to a meeting space, and they would get all the information, pre-review it in VMS. We've been doing it for 5 years that way. Then they'd go to the meeting with the hard copies of all the files, and they would review the files. When they get, they get their agenda on Thursday for their next Wednesday meeting. Over the weekend, they may drive by the 30 properties that are on that agenda, and they may look at a few of them to get more specific information or see it for themselves. And when they came to the meeting, they were prepared decision makers, just like the board is with their board level access. So these ARC members now, the only thing that they're doing different, okay, that the pandemic happens, we canceled a meeting because no one knew if we were going to meet or not, and so we canceled that meeting. We backlogged those submittals, and within 2 weeks we had another meeting, and now we're meeting every week till we go out of the backlog, and they're getting their agenda on Thursday. On Wednesday morning, the following Wednesday when they meet, they're all just jumping on the phone and they're reviewing the same information that they would have hard copy, but just looking at it digitally in VMS. And we build each of the architectural files in order, chronological, application, submittal materials, additional notes, emails, pictures, whatever, and they're just clicking on it rather than paging through it in a hard file. And we're in our second meeting cycle. It was today, and their meeting that probably would have lasted an hour and a half, 2 hours, lasted an hour, because everyone took it very seriously. They, pre-reviewed all this stuff, and they literally have it down pat. The first meeting was a little bit longer. There were some contentious submittals and a little bit of extra dialogue, I would imagine, because it was the first time. But they made it through it. They survived it, and they rocked it today. So we're going to do another one next week, and we're going to be pretty much dug out. And as I said, they're business as usual. And VMS allowed us to switch to the telephonic and the teleconference architecture review process immediately without a hiccup, because everything we were already doing was already being built in there. Each file, and an owner can see their own file, the community members can see all the files that are on the agenda, and us on the backside as the administrators are can organize it in that manner. And it was a testament to the power of that software. And people being outside of their comfort zone, sitting around a table with seven of the fellow committee members, they're able to just do it over the phone just as they were sitting there. And it was really neat. So from an accounting standpoint and a compliance standpoint, the VMS, the power of VMS is real-time information. I stated before, whether it's a delinquency or a compliance issue, board members, get phone calls, emails, or when we're not social distancing, people walking right up to us and saying, "What are you doing about that 125 Main Street property?" And they still have that real-time access. They can always email or call us as the management company. We're answering our phone, we're answering our emails, but whether they want to or not, they can circumvent us and look in the system and follow up and check to make sure we're doing what we're doing. And then a couple of the questions were, how do I communicate with my association members? No one comes to the meetings. We're having issues reaching everyone. Not everyone has an email address. As a management company, we've implemented best practices. When a new owner or once, twice, sometimes 3 times a year, we'll send out information that basically says, if you didn't get that last e-blast we sent out on, on March 29th, then you need to email this person, and this is in like a newsletter or a hard copy collateral. You need to email this person and give them your email address, or log into your owner portal and update your information so that we can reach you electronically. And if you don't know about the owner portal, please email or call this person and they will get you all set up. And we've been doing that for years. And that has allowed us to have this very easy ability to switch over to being able to reach out to everyone. So if you don't have something like that in place, I would encourage property or associations to reach out to their community and property owners. You have to send an annual meeting, a budget. You're typically sending at least one uniform correspondence in the mail every single year. That's your opportunity to add that. Fill out this form, give us your email address or your best contact information, and set a meeting schedule for the entire year, even if it's quarterly or every single month, and cancel the meetings you don't need. And now you've noticed everyone in the community on meetings that you're attempting to have. And if you're going to have a meeting in October, and that's typically when you adopt the budget, write that next to the October meeting, October 24th, 2020, proposed budget adoption in parentheses. That grabs someone's attention. And so hopefully those are, real quick little changes that you can make or things that you can implement to help reach your community. And then, we have social media is, a lifesaver for a lot of people. The property owners who don't engage in email and or social media, obviously you're not going to reach them. So sending that hard piece of mail or having that once, twice, 3 times a year, whether it's newsletter or updates, those are things that will help with that. The only other things that I got from an email standpoint, I got someone asking about CAM issues. Hopefully they're not Southern States Management Group clients. If you do have CAM issues, Diane is our best contact for getting information regarding our services or things like that. If you get a question to her regarding specifically with the CAM, I'm happy to intervene once you get that over to her. And then had a question about pest controls, rainwater structural management, those type of things. Again, business as usual. If you're struggling with a solution or not having a solution today, please contact us. We talked a lot about the rentals. I had someone talking about implementing tiered rental services. How do you do that? Reach out to Diane and or me directly. I will talk you through that. There's no reason why you can't. You just need to have a basis for it, implement it, and just don't do anything discriminatory against the Fair Housing Act or ADA when you're doing that. And then I have someone that was specifically hunting down information related to the restoration project, large project. Should we get a loan? Should we increase dues or do some type of an assessment? I've talked about this in multiple instances. The specific implementation for every association is a little bit different. Special assessments are tough because it takes sometimes 3 months to notice a meeting, implement the special assessment, give people the initial time frame to make that first payment or the full payment, and sometimes it's a graduated payment over multiple years. So if you have an elevator down and you want a special assess to fix it, that elevator will remain down until you collect that special assessment. So increasing the dues or getting a loan to bridge the gap sometimes is a better solution. We're happy to talk through whether you're a Southern States client or not. Happy to talk through some of the experiences that we've had and navigate through that. I got another question here that just came through. And then posting a meeting notice 48 hours in advance considered sufficient notice. So I would have Catherine follow up to my answer to this. So the question basically is, so we have a meeting, we're not going to have it now, and we're going to cancel it right at the last second. Okay. Do you need 48 hours to cancel it? I don't think so. And I don't think emergency powers, or I think emergency powers would support that as well. But I really don't think if at the last minute, someone, a board member, two board members have personal circumstances where they can't come to the meeting and now you don't have a quorum, you have to cancel that meeting anyway. So I think canceling the meeting is just, you want to make it, again, be as transparent as possible. We're not having this meeting, e-blast it, post it in your bulletin board, or however you're going to do it, and get it out there. And then the follow-up to that is, we're going to attempt to have a meeting at this such and such date and time, whether it's teleconference or whatever, navigate through that stuff, but continue to email blast or post notices with updates and be transparent. I think that's the most important thing. I'm going to unshare my screen, and Diane will continue to collect questions, and I'll turn it back over to Diane.
Okay, Troy, thank you so much for answering those questions. And if you could just check your email for any additional ones that came in if those weren't answered. And Catherine, are you ready to answer the questions that came in for you? And then just so everybody knows, this is the Q&A section. So if you, if you have had all your questions answered, feel free to pop off. But if you want to hear some of the legal questions and a few more management questions that came in, feel free to stay on board. Catherine, let's get you off mute, unmute. All right.
Okay, so just a couple of items as a follow-up. One is I'm seeing tweets and news reports of the governor's order coming up, and I am seeing that we talked a little bit about gyms already. Gyms are not opening. We're going to go in a phase 1 of reopening the state of Florida after coronavirus. Central Florida will be in that phase 1. Southeast Florida will not. So Miami-Dade, Palm Beach, Broward will not be in this phase 1. So gyms are not going to open up. So just to make sure I was clear and correct in what I was saying earlier, you should not be opening your community gym next week. Medical and some limited retail and restaurants will open up. There was a question about liability for injuries on private roads. And any kind of injury that happens on association property is called a premises liability claim. And you're going to be liable for negligence, or if there's some sort of breach of your declaration. So if your governing documents require you to have something and you don't have it, there could be some liability there. But generally, there can be liability. I'm sorry, just a moment. Generally, there can be liability for injuries on private roads, on the clubhouse property, on any kind of association premises, if there's negligence. So that's not doing something a reasonably prudent person should do, or doing something a reasonably prudent person wouldn't do. And that would include maybe not having signage if signage is required. If you have signage now, you certainly don't want to take it down without replacing it with something that's the same amount of clarity. I also had a couple of questions about rules that conflict with the covenants and what takes precedence. If we have passed a rule, or we want to pass a rule that is different than our covenants, no, you can't do that, right? If it's in the recorded declaration, that's going to take priority over a rule, and you can't change the declaration by rule. The only way to change the declaration is by amending the declaration. So if your declaration says we have something or we don't have something, then you can't do that by rule. But I generally find there's a lot of room. The declaration says some big overarching, and then you can define that with the rule. There's also a couple of questions about can a board strategize or have a meeting, go on Zoom without the owners? Well, anytime a quorum of the board is talking about board business, so that would be, depending on the size of your board, anytime you have a quorum and they're talking about board business, then that's a board meeting. So if you have a 9-person board and 3 people want to talk about something, that's not going to be a quorum. That group can't make the decision, so that smaller group can talk about it. You know, a great strategy is to use your management company to discuss and to bounce ideas back and forth, and you know, give your manager some direction on how you want to proceed. But you can't have gatherings of a quorum of the board without owners unless you're talking about two categories of information. If you're talking about legal information relating to a lawsuit, then you can have a legal session with your attorney and closed door that meeting. Or if you're talking about employees or personnel, then you can close that meeting. But those still need to be noticed meetings. And so there's no real way to get around kind of doing business so that your owners can see it, except when it's not a quorum of the board. So one-on-one with the manager, or one-on-one with two board members if you have more than a 3-person board. And I did have a couple of final points. You know, restrooms adjacent to the pools, can they be reopened with the pool? Probably. I'd want to look at that, and you know, I am seeing the development of guidelines where even, you know, as you know, Disney looks at opening up its facilities, they're going to be every other sink in a restroom, or, you know, we want to maximize physical distance. And that was something that I saw in the governor's press conference. He was talking about, you know, vulnerable individuals should stay home, and all individuals that go out in public should maximize their physical distance, that we're still social distancing, but we're not doing that safer at home order, and we're phasing in the opening up of medical, you know, retail, and then in the separate later phase, we're going to have bars, restaurants, that kind of thing. Hair cutting, again, will be in a later phase. I do reiterate everything Troy was saying about assessments. You know, I don't think now is the time to stop trying to collect them. I don't think now is the time to publicize some, you know, we're not going to collect them from you. No. But if anyone is coming to you, you know, every owner that needs something should be offered a similar deal, right? We want to treat all our owners equally. And if you're going to waive a late fee or put them on your normal collections plan, you know, try and do that the same with everyone to the extent you can. There are some cases that have been suspended. Mortgage foreclosures right now have been suspended under Florida law, and residential evictions have been suspended right now for failure to pay under Florida law. But an association's foreclosure for assessment non-payment, that hasn't been suspended, and commercial evictions, or evictions for, you know, bad behavior. So if you have a non-compliant tenant and you have a homeowner who wants to evict them for some reason other than non-payment, those haven't been frozen yet. So I know there was a lot of information. It was kind of a potpourri of information, but there's a lot going on legally right now. And so whether our firm is your attorneys or you have other attorneys, if you have legal questions, you know, please get with your attorney and figure that out, so that you can do it right. So you can do your collections correctly, so that you can handle other issues correctly. And I'd encourage you to speak with me offline or speak with your association's attorney to answer more specific questions. Thank you very much for the time today.
Okay, Troy, if you want to get back on video here and answer some of the questions that came in from, or for management rather.
It's saying that you have to stop my video, so just start it back up because you shut it down.
Sorry.
All right. So the one of the questions that came through that I wanted to address was board meetings. They get canceled. You know, what is the association responsible for providing from an association member standpoint? I think specifically the question was about financials. From a management side, or whatever solution you have as an association, the association records should continue to collate and be developed and kept. You know, most boards, you know, they'll have a treasurer's report or financial report, and they may be adopting the financials as presented in that meeting. And then, you know, one of our best practices is we don't necessarily post the financials in the owner portal or, you know, e-blast them out to everyone. We would make that a records request. And so if an owner wanted, you know, a balance sheet or a delinquency report or something like that, they could send an email and we would get that information to them at their request. So hopefully that answers your question. If your formal process is to not make financials available until the board adopts it, and then you post it somewhere or whatever, then you can do one of two things. You can withhold it until you have that meeting, which I wouldn't necessarily think that that's the best thing to do. Or you can have the management company or whoever's preparing it create a draft version and just put a disclaimer on it. This is a draft version of the financials until it's formally adopted at an upcoming board meeting. Hopefully that answered that question. Question: how do you present assessments to resident community for a capital project expense? Number one, there's if you're going to levy a special assessment, formal process in accordance with the statute. If you are reserving for something and you're going to actually take the money out of reserves and then go do it, say like pave the roads, and you've budgeted for that over a period of time, and you're at the point, the life cycle where you're going to do it, you just need to formally do that at a meeting and make a motion a second to expend $100,000 to repave all of the roads. And then the board can use the funds as designated in their reserve account and how they've been reserving for it, and go in and put that in play. What are strategies in dealing with consistent complaining neighbors who live outside the HOA? And then another question about serial complainers. I'm just going to reiterate what I said before. Being consistent, equitable, non-selective, and transparent on how your collections or delinquency or addressing renters, you should have already been doing all of those things. And if you have not implemented a formal process and policy and posted that somewhere in a portal or on a website, or made it available at request, then I think I would endeavor the board to just have a real quick discussion and then identify a formal process for addressing delinquencies, compliance issues, and then in under compliance issues, what happens if there's a renter issue, and just be consistent. And that's how you respond to the serial complainers. You're operating as normal and you're fulfilling your responsibilities. Best day for the association is, why are you doing or not doing something? Because the documents say so, or the statute says so. That's your best day. You don't do it because someone keeps complaining about it, or it's because you feel like it. It's because the documents obligate you to do it. They say so, and you have to fulfill that. And then one of the last questions was importance in hiring licensed contractors. All of our forums, when we talk about contractors, we typically address this. Licensed, insured, those type of requirements are vital to the association limiting exposure. Just want to make sure that everyone knows that there are contractors that are out there that operate, that can do what you want to do for a great competitive price and are licensed and insured. If you're having trouble with that, contact me or Diane. We'll get you plugged in, even if you're not a client of ours. And then lastly, recruiting new board members. That's an ongoing process. Any person who attends a board meeting, if they show up regularly or once in a while or their first time, you should always engage them in conversation as a board. Have them introduce themselves, not on the spot in the middle of the meeting, but maybe afterwards or before. As the board president, maybe that's a great opportunity for you to reach out. Hey, what's your name? Where do you live? Oh, I'd love for you to participate. Even at the board level at some point. Just want to make sure you're comfortable. If you have any questions, concerns, you can talk to me offline at a later time, or send me an email or something like that. So that pretty much concludes my my presentation. I'm going to turn it back over to Diane to close it out.
Okay, everyone, at this time, we're going to close it down. So there was a few legal questions that came in right at the end, and I would just highly recommend that you contact Catherine directly, and her email is kmiller@surfcoastlaw.com. Again, kmiller@surfcoastlaw.com. Additionally, we will be putting this video up on our website, which is daytonapropertymanagement.com, and it will be under the news section for any board members that you have that may not have been able to attend. And we thank you very much. Stay safe, be well, and let us know if we can help you with anything. Good night.